and enact the Administration of Criminal Justice Bill 2022 to, among other things, provide for the establishment of the Administration of Criminal Justice Monitoring Council for effective and efficient administration of justice in Nigeria and for related matters. Mr. President, my dear colleagues, I respectfully rise to lead the debate on the general principles of the Administration of Criminal Justice, Repeal and Enactment Bill 2020. You recall that the bill was first read on the floor of the Senate on Wednesday, 2nd February 2022. The bill, in a nutshell, seeks to repeal the Administration of Criminal Justice Act 2015 and enact the Administration of Criminal Justice Act to, among other things, provide for the institution/legal framework for the administration of criminal justice system with a view to promoting the efficient management of criminal justice institutions and speedy dispensation of justice in Nigeria. The bill also seeks to establish the Administration of Criminal Justice Monitoring Council, which is akin to the Bureau of Justice in the United States of America and the London Criminal Justice Board. In this jurisdiction, these respective bodies provide directions on operational delivery aimed at improving the efficiency and effectiveness of the criminal justice system by bringing together criminal justice agencies to support joint work targeted at improving service delivery in order to reduce crime, recidivism, and unnecessary confinement. All these efforts are well streamlined and structured for the promotion of safe and fair criminal justice system to enhance quick dispensation of justice. You recall, dear colleagues, that the Administration of Criminal Justice Act was enacted as an act of the National Assembly in 2015 as a legislative interventionist measure to address the slow pace of administration of justice in Nigeria, where criminal trials, especially high-profile cases, go into extinction without conclusion. This ugly scenario gave rise to unwarranted delay at interlocutory stage, where defendants could appeal up to the Supreme Court on trial within trial, objection to admissibility of documents, and no case submission. Therefore, the Eastern Act was enacted by consolidating the Penal Code Act and the Criminal Code in order to have a harmonized procedural law for effective and efficient justice delivery system in Nigeria, in line with the jurisprudential theory of administration of criminal justice generally. It is instructive to note, Mr. President, that the enactment of this act is one of the novel interventions in the administration of justice in this country. However, in the course of its implementation, certain inherent shortcomings that border on some of its provisions being incongruous with the provisions of the Constitution of the Federal Republic of Nigeria, 1999, were noticed. As a result, there are judicial pronouncements on some aspects of the provisions of the Act, which require modifications and holistic review for the seamless and effective administration of justice. Accordingly, the proposed bill has been painstakingly structured and streamlined in order to address all the noticeable shortcomings, as well as makes all-encompassing provisions in line with global best practices to ensure that we consolidate on the gains/achievements the country has recorded in our justice sector in the past few years. In the light of the foregoing, the objectives of the bill include the following. To wit, 1, to provide prosecutorial guidelines to improve prosecutorial accountability and transparency in order to guide against the whimsical exercise of prosecutorial discretion in determining cases so as to build public confidence. 2, to establish the Administration of Criminal Justice Monitoring Council to provide proper coordination and monitoring in order to drive criminal justice development policy and programs across the country for effective justice delivery system through collaboration and engagement with the prosecuting agencies to ensure speedy investigation of criminal cases in line with the purport of the bill. 3, to streamline the provisions of the Eastern Act, which are in conflict with the provisions of the Constitution in light of subsisting judgments of courts. 4, to widen the definition of court so as to make Administration of Justice Act applicable in appropriate circumstances in the states. This is intended to eliminate obstacles faced by anti-graft agencies in the course of prosecuting cases at state high court, especially in states that are yet to enact the administration of criminal justice law. And finally, 5, provide uniform sentencing policies and more restorative justice mechanisms, such as victim-offender mediation, suspended sentence and probation, and community service, etc. For the avoidance of doubt, I wish to clarify that the Council proposed to be established pursuant to this bill is not a new body. Sections 469 and 470 of the Extant Act establish the Administration of Criminal Justice Monitoring Committee with its powers and functions clearly spelled out. Although the committee has been functioning under the Federal Ministry of Justice, its activities and operational efficiency has been limited due to minimal or lack of funding. To this end, the proposed bill intends to grant statutory powers to the proposed council in line with global best practices in the overall interest of this country. Finally, it is pertinent to state, Mr. President, distinguished colleagues, that the establishment of the proposed council will not pose huge financial burden on the government, as the Administration of Criminal Justice Monitoring Committee, established pursuant to Section 479 of the Eastern Act, is already being funded through the Ministry of Justice, budget. However, in compliance with Order 76, Rule 3 of the Senate Standing Committee Orders 22 as amended, a financial compendium showing the financial implication of the proposed council on the public treasury is hereby attached for your kind consideration. On this note, I hereby appeal to my dear colleagues to support the expeditious passage of this bill because of its laudable and strategic relevance to the ongoing justice sector reform in the country. Thank you for your kind attention.
And to second reading taken. And the bill is referred to the Committee on Judiciary, Human Rights and Legal Matters for further legislative action to report by within 4 weeks.